We're ready to roll. This is the tiered registry law, a report card for year one of the petitioning process. So basically, we're going to start with the practical aspects of the law. We're going to do some critiquing. We're going to grade it, and then we'll open it up for discussion. How's that sound, Alex?
Excellent.
All right. Well, then, Alex, go ahead.
Okay. So just for those who need a little bit of context, this whole discussion kind of began around something called Senate Bill 384, which was passed by our California legislature, and ACSOL and a number of other organizations were responsible for getting this thing passed. It changed things in California. It's not perfect, but it did provide an avenue, because California was one of 4 states in the country that had a lifetime registration, and it moved us into what is now called as the tiered registry, creating 3 tiers: tier 1, tier 2, tier 3. We'll talk about that. So the actual law went into effect, or was on the books in 2017, but it didn't really go into effect until July the 1st of 2021. So we have about 14, 15 months now of experience since the tiered registry went into effect. And one of the things that was part of the bill was that it didn't go into effect until July the 1st, and individuals had to wait until their birth date to actually file a petition. So what happened after July 1st, 2021 was people began to file petitions. And the petition was created through a process through the Judicial Council, and we're going to show you those petitions and kind of work through them. But the first step was that individuals had to go where they were registering and had to get 2 pieces of paper. The first piece of paper was proof of their registration, and each of the registry offices had this proof of registration. The second thing they needed to get was a tier designation letter, which indicated the tier that they had been designated in by the California Department of Justice. Now, as I mentioned, there's 3 tiers, and tier 1 was 10 years, beginning from the date of release of incarceration. Tier 2 is 20 years, beginning from the date of incarceration. And unfortunately, tier 3, which we'll talk about, it remains a lifetime registration. And we tried to get that narrowed, and it actually got expanded at the last moment. So that's where that child pornography aspect of it comes in, and we'll talk about that. So bottom line is that these forms were created, and I'm going to go to hopefully the PowerPoint now. And see here. What you should see here is the front page of Form CR 415. This is the petition to terminate sex offender registration pursuant to Penal Code Section 290.5, California Penal Code Section 290.5. And these forms are available on the internet. If you go to www.courts.ca.gov, I don't know whether you can see it, but in the bottom left-hand corner of the form is mention of this website. Again, www.courts, What happens is you go then to the forms, and you'll find if you just type in CR 4-4 you'll find the petition to terminate sex offender registration. And that's the form that's up there on your screen right now. So there are two things. There's the form itself, and there's actually an information packet. So you can check out the information packet on the web, and then you can check out the form. And if you can see on the screen here, you can see that some of the areas that need to be filled in are actually in blue, and you can fill it out right on the computer. So it's very easy to just go ahead and fill it out on the computer. I want to start by just going through this briefly with you, and that is obviously the name of the petitioner is in there with the date of birth of the individual, so they can verify that you were eligible. At this point, of course, we're past that 1 year, so everybody should be past their birth date. But the bottom line is that you have to put in the Superior Court where you're going to file this, and then the case number is the case number of the case that got the individual on the registry. So it's important to put the case number or case numbers in there. If the individual is going to be represented by an attorney, there's a place for that information to be put in on the form. One can file this by themselves. There is no filing fee. And the other options, of course, are to have an attorney handle it. There are public defender offices throughout the state that are handling this at no cost. And then there are attorneys in the community. So it's up to the individual whether they want the assistance of an attorney, but that option is up to the petitioner. The next area is important because that's where the individual indicates that they're currently registered and where they're registered. So this is under the 2 category on the form. And there the individual will put the county in which they are registering. And then at the bottom, under that is B, where you identify the court that you were convicted in and the case number, if possible, for that case. And so you'll put in the Superior Court of California for the county of whatever county it is, and then the case number. Again, there's verification that this petition is being filed on or after petitioner's next birthday after July 1st, 2021. We've already discussed that. And D, that proof of current registration is attached. So that's that letter that you get from the office where you register. So the letter from the police department or sheriff's office or whatever that verifies that you are currently registered. The third paragraph, which is at the bottom there, is the termination request. And the box there says, petitioner requests termination of the requirement to register as a sex offender in California. Going to the next page, 4 are any pending charges. And it's important, again, to be in compliance that, to your knowledge, there are no pending charges against you, and that if you do have that, of course, that could extend the period of time for the individual to get off the registry. Number 5 is your custody status. Again, you're checking the box, hopefully, to say that you're not in custody, jail or prison. Number 6 is your supervision status. And again, hopefully the individual is not on parole, probation, post-conviction supervised release, or any other form of supervised release. And then 7 gets us into that tier designation and eligibility. And it gives the opportunity to check the box where small a is tier 1 as an adult, and the petitioner has registered for at least 10 years. If that applies, the boxes are checked. The next one is tier 2. And again, I'm not going to read through these, but this is where the petitioner has registered for at least 20 years. And then there are some other ways of filling out the form. And then the third one is tier 3. And on that situation, we'll spend a little bit of time talking about it, but that's the one that remains technically a lifetime registration. At the bottom, you'll see 8. That's whether there has been any previous petition that has been filed. If so, you have an obligation to fill that part out. And then moving last page of the petition, number 9 says the registration period. The petitioner believes that they have met the requirements to register for the time period required by petitioner's tier designation as determined by the Department of Justice. Now, one of the problems here is that the Department of Justice was given until January 1st of 2023 to determine what tier an individual is in. And to date, they haven't done that for everybody. So there are individuals who have not received a tier designation, and technically, at least the way prosecutor offices are looking at it and some courts, you really don't have the ability to make your application until you have that tier designation in 1 or 2. But again, starting on January 1st, 2023, it's our belief that at that point you should be designated or should be able to go to court and ask the court to give you relief. All right, so that's the petition. And again, it has, yes.
Before you move on, just one point on that petition, and it's the most common area that's missed on this before we move on to the next one, is item 8. A lot of people just pass that up. And what happens is, if you don't check a box, either has or has not, and most of them are going to be has not, because this is going to be the first time you petition, it's just going to be rejected and sent back. So make sure you check that box on item 8. Just a tip for doing petitions. Thanks, Al.
Absolutely. And then, of course, it does, as I said, have a place for you to sign it, or an attorney is representing you, the attorney signs it. Okay, so that's the petition. Part of this process requires that there be a proof of service of the petition. So the next document that I'm showing you is a CR-416. Again, this is available on the Judicial Council website. It's another one of those forms. So you just use that same website and you type in CR-416 under forms or under your search, and this form should pop up, CR-416, which is proof of service. Now, this is essential. It's an essential element of the process. And so once the petition is filed and you have it filed with the court, then a copy of the petition has to be served on 2 entities. And this form lays it out for you. So basically, again, you can serve it, but you have to be at least 18 years old to serve it, and it can be served either by mail or in person. And this proof of service, again, indicates that that requirement has been met. So number 2 is the individual who is doing the serving. And then number 3 indicates who this petition has been served on behalf of. So If it's on behalf of the petitioner, then that name should be in there. Number 4 indicates I mailed or personally delivered a file stamp copy of the petition to terminate sex offender registration. That's that CR-415, and proof of current registration to the agencies below. Okay. Again, attached to the petition, in my opinion, should not only be the proof of the current registration, but also the tier designation. And then under 4, these are the entities that need to be served. So 4A is the registering law enforcement agency. So that's the agency that you're registering with at this time. And the name of the agency, the address, and the date of service. And then below, it indicates that they were, who it was delivered to or that it was mailed to. So if it's mailed, it says mailed the documents to the agency at the above address above in a sealed envelope from, and you have to put in what your city and state is, by depositing the envelope with the U.S. Postal Service. The other one is delivered in person, and there it's important to get the name, and if it's a law enforcement person, I think it's appropriate to put their badge number at what time on that date you actually serve them at the above address. So that's the registering law enforcement agency. The one under that is small b, that's the district attorney in the county of registration. So once again, the county of registration, the district attorney's office. And so there, again, you'd put in the address, you put the date of service, and you have that option that we were talking about, either to do it by mail or to deliver it in person. Going to the next page, there is a, under C, this would be the law enforcement agency in the county of conviction if it's different than the county of registration. So again, if the county of conviction is where you register, then you only have to fill out A. But if the county of conviction is different than the county of registration, then you need to serve them as well. So you have to serve that law enforcement agency and show proof of service in the C column there. And then below that is a one to verify that the district attorney is served, again, only if it is the county of conviction is different than the county of registration. So at that point in time, you need to be able to show that both the district attorney in the county of registration as well as the county of conviction, if it's different, have been served. And then it's signed. And again, this gets served or filed with the court. It's essential. If you don't do this, it's not official. The next document, unless Chance, you want to say anything about this one?
No, I think that's good.
Okay, so we'll move on then to the next form, which is CR-417. And once again, you can see this form in the Judicial Council website, that www.courts.ca.gov. You can find this form. It's CR-417. It may be of interest to you, but technically this is the form that is the response by the district attorney to the petition to terminate sex offender registration. So this is the form that is filed by the district attorney. Now, in reality, the law enforcement agency believes they have 60 days to review the petition and to then get over to the district attorney's office their position as to what they think about the petition. Has the individual complied with registration, and is the individual in the appropriate tier? And that verification gets sent to the district attorney's office. Now the district attorney's office has an opportunity to review the petition, and they file the CR-417, which is the response to the petition based on the information they have. And again, 60 days for them to get to the court with their response. On this form, again, it's the district attorney who's filling this out, but they put in the petitioner's information. They indicate what tier the individual is in. They indicate their response. And so that's number 2 there. And their response, hopefully, is small a, which is the district attorney has no objection to this petition. If that's the case, at least my experience is the petition's going to get granted. So that's a good box to be checked. However, there are other boxes here, and it gives the district attorney the opportunity to object. This is B, object to granting the petition and request a hearing. Again, I'm from San Diego County, and in our county, we have a particular judge that has been assigned to deal with these cases. And if the district attorney's office files their CR-417 with their response that they have no objection, it goes to that judge, and usually within 2 weeks, the petition is granted. And I'll show you the next document, which is the order. However, the district attorney is in a position to object and can ask for a hearing, in which case the court can then set the hearing. And you'll see on each of these forms, there is a place for date, time, and department to have a hearing. So that would be something that would occur if the court's going to set a hearing. Now, one of the things that they get an opportunity to do here is check the box where they object, where they allege community safety would be significantly enhanced by the petitioner's continued registration. And I don't know how much time we'll have today, but we can talk a little bit about that. But obviously, what community safety is a question, and their allegation of such is sometimes questionable. The next one is petitioner has not met the requirements of the penal code. And of course, that's another thing. That's a different situation. And C, the district attorney requests the petition be summarily denied because, and here are some of the problems. One, the petitioner has not fulfilled the filing and service requirements of Penal Code Section 290.5 because, again, that could be the improper no service, no proof of service, or what have you. 2, there are pending charges against petitioner that could extend the time to complete the registration. 3, petitioner is in custody or on parole, probation, or supervised release. 4, petitioner does not qualify for termination because petitioner is in Tier 3 as a lifetime registrant and does not fall under the risk level exception. 5, petitioner is in Tier 1 or 2 and has not met the mandatory minimum registration period, which we were talking about, the 10-year or 20-year. We didn't talk at all about juveniles having half that time, so 5-year or 10-year. 6, petitioner is in Tier 2 and has not met the following criteria for a 10-year registration except 7, petitioner is in Tier 3 solely on the basis of risk assessment level and has not met the following criteria. And 8 is other. And so, again, I had an experience where it was other because we had pulled back a petition due to the fact that the client hadn't been designated yet into a tier, and the judge basically indicated he was going to deny the petition. So rather than having the petition denied, we withdrew it. The DA filled that out to indicate, there had been this action, but things had been cleared up. In any case, that's CR-417. last form is the actual order. And that's up right now on your screen. And that is the CR-418. Again, it's not something that the petitioner fills out. It's something that the court fills out. But it does provide for the recognition by the court in number 2, that the court grants the petition to terminate the sex offender registration requirement under Penal Code Section 290 and beyond. So that's the good news. If that box is checked, and on the next page, which I'll show you in a moment, the judge has signed off on this, you are off the registry. That's it. And from that point on, you have no obligation to register in California.
Okay.
And then let me just finish this up. If I may, there are provisions for summarily denying the petition. I kind of read some of those off of the DA one. And then number 4, which is on the next page, which is up now, after hearing the court denies the petition to terminate and based on, and either A, the petitioner has not met the requirements, or community safety would be significantly enhanced by petitioner's continued registration. And then the judge signs it and dates it, and that's it. So those are the forms that are provided for. And like I said, they're on the website. You can look at them, and they can be filled out online. So I will stop the sharing, and now we're back with you in person.
And this is I think that Alex has really laid out methodically the practical aspects of how this instrument, in theory, is supposed to work. However, that's in theory. Part of what we're doing today is kind of critiquing this process, and we're not going to have a whole lot of time to really get into the weeds here. But what I'd like to just say straight off is that in critiquing it, as far as I can see, there are a few areas of concern. One is inefficiency in designating. 2 is lack of training universally across jurisdictions and with all respects to law enforcement, courts, and others involved in this process in the state. And the 3rd is lack of coordination. And in looking at this system overall, I mean, the avenue of relief beforehand was a certificate of rehabilitation. And sometimes people get confused here. They think that you can still get a certificate of rehabilitation and be relieved in this state of the duty to register. You cannot anymore. You can get a certificate of rehabilitation, but in order to be relieved under 290.5, you've got to now go through the petitioning process. Okay, and so let's start our critique. And Alex is going to jump in, I'm sure, because this is where the rubber meets the road here in the report card process of this panel. One is classification. Well, I think that everybody can agree it's inconsistent and unjust. You've got misdemeanors, some felonies on tier 1. You've got semi-serious felonies on tier 2. And then you've got a mix of misdemeanors, very serious felonies, and some that are just lower threshold, should be on tier 1 type misdemeanors. It doesn't make any sense. It's a mishmash. And so to begin with, the classification scheme of this process is flawed. I mean, at base, if you think about it, we don't really even have a tiered system. We have a tier 1, we have a tier 2, and then we have a lifetime tier. The only folks ever coming off the top tier are people that are tier 2 that are up in tier 3 because they're high risk. And if they eventually can show dynamically that they're not high risk anymore, which is damn near impossible in this state and probably in the world or the universe, they come down to maybe tier 2. So this is a problem inherently with the system. The other thing is there's no off-ramp on tier 3, nothing at all. So that means that if you're a tier 3 designee, you're staying on tier 3, whether you've suffered a felony or a misdemeanor. For instance, a tier, I don't want to get into the sticks. I want to generalize because I know we're going to have a lot of specific questions. So let me just move on and we'll get there. Another issue is, as Alex mentioned, designations to be determined. Now, there are problems with that. There are out-of-state folks who have been convicted who are to be determined because the classifications haven't been done yet. And that is a process, and it gives discretion to the DOJ to do that. Okay, there are in-state convictions that are obvious to all of us. If you get a criminal history and you're looking at a misdemeanor conviction and there's nothing on that history that has to do with any other sex convictions, you know it falls in tier 1. We all know. We know, the DAs know, the judges know. Yet, as Alex says, it halts the system. No one wants to do anything unless the DOJ designates, even if it's obvious and right in front of our face. It can be summarily denied, or it can be continued, or it can be just not filed. And that really gums up the system. The other thing is that in terms of training, the DOJ hasn't set out a booklet, an instruction guide, so that every jurisdiction can universally across the board do things methodically to move this along. Now, is that purposeful? I don't know. But the fact is that every jurisdiction is different. So for instance, one, you got to figure out which court. Now, generally, there is a general discussion of which court, like where you live. It's the court that operates where you live. Well, what if that court was closed during the pandemic? What if that court only does civil matters now? LA does it totally differently. They say wherever you got convicted, that's the court you go to. So if you're living in Glendale and you got convicted in Van Nuys, you got to go to the Van Nuys court. That's not what the state law says, but that's the way they're doing things in Los Angeles. So which court is it? That's a dilemma. 2, assignment of case numbers, or at a minimum, a court's indicia on the petition. A lot of courts are loath to put any kind of number. If you put the case number in the box, they'll say, well, that's from foreign jurisdiction. We're going to assign our own case number. Okay, that could hold up your petition or get it summarily denied. If you allow the court to make that determination and there's no indicia, there's no stamp on that petition, and you want to send the other petitions out to serve law enforcement agencies in a proof of service, okay, they will send it back and say, we're not going to accept that because it doesn't have any court stamp on it. Some courts say that if you don't file the proof of service with the petition, we're rejecting it because it's incomplete. It's an incomplete filing. It's kind of crazy, but there are problems. And also, when
Chance,
yeah.
could I just jump in? Again, as I read from the actual form, though, it makes absolutely no sense. The form tells you to file the proof of service after you've served them with the filed petition. So how can you have a filed petition if you have to file your proof of service with the filed petition? It's ridiculous. Well,
somebody should let San Bernardino know that's the case. I've tried several times. This is, and it's not just San Bernardino. The problem is lack of training and coordination, because there are many jurisdictions that are actually using clerks to determine this, not a clerk, many clerks who have not studied the law, don't know what's going on. And then some are assigning it to one clerk. And then, of course, everybody's doing something else. Now, the reason I say that is because I move up and down the state and I do these things. And so I'm in many different jurisdictions. And these are issues that cause problems, and it slows up the process. And they have to be cured or mended each part, each part of the way. And then you look at law enforcement, and I'm still on lack of training. They reject petitions that haven't been stamped yet. They refuse to correct errors in the reports that they submit to the courts because they say that's the DOJ's jurisdiction. And it's unclear as to who is to receive the report. A lot of law enforcement folks are under the impression, without looking at the law, that they should send this to the clerk, and it's the clerk that should send it to the DA. The problem is with the time aspects of this law, that law enforcement has 60 days to complete the process. When they send that report to the courts, it has to get to the DA's desk before the clock clicks. So you've got a lot of problems there. And then if the DA checks the box and submits it back to the court, it could sit for a while unless you nudge them along. So these are problems. So there's lack of coordination. There's no handshaking here really between communicating between the DOJ, law enforcement, and the courts. Now, you would think, well, this is all going to work out. This is the first year. You know, there's a lot of stuff. And you know, you're probably right. But if you look at it and you compare it to the statistics coming out of the Sex Management Board up in Sacramento, you can see pretty clearly what's going on here. Two things. Well, let's just take their report. Their recent report says during the first 14 months, which is July of 2021 to August 2022, according to the California DOJ, a total of 3,984 petitions have been filed during that period. Of that total, 2,012 petitions have been granted and 174 petitions have been dismissed or denied. No further breakdown. So, and dismissals include no tier assignment. There are currently 1,798 petitions pending. This is a fraction of what it should be. We have over 100,000 registrants in the state of California. And, you know, although I think it's good news that a large proportion of them are being granted, and although I have seen personally law enforcement folks that have stepped up, and also DAs that have just gone out of their way to be equitable, out of their way. And I'm impressed. You know, my thinking, and I don't know, and I'm going to ask Alex the same thing, given the inefficiency in designation, the lack of training, and lack of coordination, and the general numbers, you know, and the population we have here in California. What Alex, what would you grade? What would you grade the registry as a professor?
You mean the way it's going right now?
Yeah, the new tiered system. As at this point, what kind of grade would you give it?
Probably a C-. I think, you know, I mean, because as you said, there are some positives, there's some successes and some good news. But again, for people who have been abused all these years, this was supposed to be something that they thought about and could make it work. And I think one of the things that's interesting is, and again, my perspective is somewhat limited because of San Diego, but just in talking to the people at the law enforcement offices, they actually like this because it makes their job easy. You know, they no longer have to, you know, have these people coming in and that they have to go through the process of registration. They don't have to go out to their home and do the, you know, the address checks and things of that nature. You know, they actually have been positive about this. And so I know that may not be the case throughout the state, but at least that is part of it. And the same thing is true with the district attorney's office. They have a unit, they have a couple of people who are dealing with this. They're experienced in this area, and you can talk to them about this. And so there is, you know, and as I said, the court has kind of set up this situation. So this one judge is, and it's, you know, we have 4 adult courts in the county, but it's central, the one court that's actually processing this thing. And there's one judge who's signing the orders. So I think that there is a, you know, a situation that where this thing is still relatively new and is moving through, but it is frustrating. And part of the frustration is the lack of registrants exercising their right to get off the registry. And I've talked about the frustration that we've always had with respect to Penal Code Section 1203.4, which is expungement, and the fact that people don't take enough advantage of that. Well, here's another example where we have this vehicle in place and people need to take advantage of it.
I agree with, you know, I agree with you completely. I give it a C- too. Alex and I, without even talking about it, but just understanding the dynamics as we've discussed it today, are in agreement. And we're also in agreement that the general knowledge of law by registrants really sucks. We need to get the word out there. Everybody needs to get the word out there. The DOJ and everybody else involved in the system needs to get the word out there that there is a remedy, and people should be taking advantage of that remedy. It's there for you, and not to hide from it, but to embrace it and to get off of this horrendous chain, this registration. So we're at 2:20 right now. I'm sure people have questions.
I have a comment.
Okay,
I have a comment.
comments.
Yeah.
Perfect.
Okay, great. On this specific topic, because there's some chat going on or some comments going on in the chat part of it as well. People are asking about why so few people have in fact signed up or filed their petitions. I really think that it's because so few people know that the tiered registry law even exists. And, you know, despite our best efforts there, and despite the best efforts of some DA's offices even, and I think Alex San Diego has done a good job in sending out the information. Orange County, I know they've sent out packets of information as well. And so we, as an organization, we reached out to the Sex Offender Management Board here in California, and we asked them to help get the word out as well. And we think that they have a vested interest in the tiered registry law because they in fact supported it very strongly. And quite frankly, I think they helped us get it over the finish line, the law. So, but you know, we're open to suggestions, folks. We folks at ACSOL. So if you have any ideas of how we can do this, besides Janice standing at every registration office in the state, please, I can't do that, handing out flyers. But anyway, we're certainly open to other ideas about how to get the word out.
Okay.
I see you have some hands up.
We do.
So Paul, I have just unmuted you.
Hi, guys and gals. I've got a question. So in your experience, what is the chance of a sex offender getting a certificate of rehabilitation? I don't qualify to get off the tiered registry, so I'm wondering what my chances would be.
Well, that's a very tough question without really understanding the background and facts of your situation. What I would suggest to you is contact an attorney, you know, individually outside of this conference, and someone who knows exactly what you're talking about. But remember, that's not going to get you off the sex registry. It's now the tiered system, and it's unfortunate, but you know, I wish we had two avenues. I wish we had more, but we just don't.
And now Jeff Stein has his hand up, and after him, David.
Good afternoon. I started working on this issue decades ago as a lawyer doing clients with registration and sex offense issues. I worked in the legislature for a significant amount of time before SB 38 was envisioned. And the opposition that kept the law from changing was law enforcement and victim groups having the inside track. 2014, the Sex Offender Management Board published a report called Tiered Registration, a Better Path to Community Safety, which really was Carl Hansen and led to the revision in thinking that in 2017 produced a change in support. So if you look at SB 384, the bill that was enacted that reformed and created tiered registration, they list all the groups in support, which included DA's offices, law enforcement, victims groups, and the groups in opposition. There was none. So what Janice was saying, that the current vision is that there's law enforcement support, is absolutely true. Law enforcement basically no longer resist because they've been educated to the efficacy of getting low-risk people off of the registry. So the question for people who are petitioning really becomes, do you submit a petition on its own, or do you submit a petition that's augmented with information that confirms the low-risk nature of the applicant? The standard on this is that people aren't entitled to be terminated unless their removal would increase significantly the risk to the community. And so there's space in every application process to submit confirmatory information that's outside of the petition's bare contents that establish that people are not presenting a risk. and therefore their removal would not elevate the community risk. I think that's really critical. There's another pragmatic information, which is that outside of the drafting of the legislation, there's complete chaos in the courts as to how each court administers this program. I practiced in San Luis Obispo primarily, and we had, when this law was getting ready to go into effect in the fall of 2021, the court had not envisioned it. I was able to get a consortium of the court, the DA's office, and I was representing the defense bar, and administratively created a process which is now working very smoothly and in San Luis Obispo County. And I think in general, you have to explore each of the clerk's offices, develop communications with the clerks to figure out how they process cases in terms of assigning case numbers before you file your petition, or else you run risk you're going to be needlessly suffering a 1 to 5 year delay in getting this granted.
Okay, thank you. Appreciate that. And I agree with that. That's absolutely true.
And now you have David waiting. David, you're unmuted. David?
There we go.
Sorry about that.
No
I went to
problem.
click the mute and ended up. Anyway, Alex, thank you for being here, part of the panel. I'm a former legal assistant for 20 years. I've been involved in in orbiting this issue, and I just have a couple of really quick clarifying questions for you. I noticed there was a box on the form under Tier 3, the submission form, and it says there's a risk exception. Does that mean you're assigned to a lower tier, but because you are considered of higher risk, you become Tier 3, or does that mean that you're Tier 3 and you have a lower risk assignment, and so there's a risk? So is it a lower risk exception, or is it a higher risk exception, that box?
It's an exception. So it's an exception to Tier 3, which basically is a lifetime registration. So it's, I guess, envisions the ability at somehow to fit into an exception. But that's an area that, again, is going to be litigated. This is where work still has to be done. And I noticed that Janice mentioned this as well. ACSOL certainly wasn't happy with some of the people that were put into Tier 3. The rug was pulled out at the end with respect to the possession of child pornography cases, and hopefully this is going to get revisited. But at least we have a structure now that we can build on and amend, and hopefully in the future some of these limitations will be removed.
And then in terms of, because we've talked extensively about state, but in terms of federal, the way that this interfaces with SORNA registration requirements. So obviously you're required to register under the laws of the state in which you reside. So I assume all of this just applies for California, but are you aware of any additional responsibilities outside of, I'm a California resident and a San Diego resident. And so are you aware of any, but I had a federal conviction. And so are you aware of any SORNA related exceptions that would still require responsibilities once you are off the tier registry in California?
Well, Chance, you want to do this, or you want me to?
Well, that's a good question. I think that's what the SORNA litigation is all about.
Right.
So as soon as we get to the bottom of that, I think we'll be able to answer your question, but it remains now something we'll know more about in the future.
Sure.
Yeah.
And I've been babysitting that case too. Thank you. Thank you very much for your time.
Thank you.
And Chance and Alex, you have about a minute left.
All right. Well, seeing that there's no more questions, I guess I'll take the time to just thank everybody for joining us. We really appreciate it. And thank you, Alex. It's always an honor to be with you and doing anything we're doing in a conference. I enjoyed it. Thank you.
Thank you. And stay tuned. Hopefully we'll have good news to report in the future.
All right. Thank you, everybody. That's it.